Okay.
We are proceeding with post-judgment matters on the Ghibaudo and Kellogg matter, case D 2015-522043. We are on the record in the Regional Justice Center. Mr. Reed and Ms. Kramer are appearing by telephone pursuant to administrative order. Mr. Reed, first, please state your appearance.
Thank you, Your Honor. Christopher Reed, board number 6791, on behalf of Tara Kellogg. I have Ms. Kellogg with me here this morning.
All right, Ms. Kramer.
Good morning, Your Honor. Shanty Kramer, 11545, for the defendant, who's in the office with me.
Okay, great. All right. There were various filings since this matter was decided. We had evidentiary proceedings. The court made a record at the hearing on September 24th, and the findings of fact, conclusions of law and order were filed on November 10th, 2020. Immediately thereafter, Mr. Reed, you filed a motion or a series of motions asking for judgments related to costs and fees, and they've been responded to. There's been a series of responses that are filed. There was a stipulation to consolidate the hearings from all of these, and they were set for today. The only thing that's been happening between these folks is the order upon consent that the court signed as the responsible judge in the R case that was filed in January. Now, since the findings of fact, conclusions of law were filed, both parties have exercised their rights to file notices of appeal. One party, the defendant, filed on the 14th of December, and the plaintiff filed the 17th of December. So we do not have jurisdiction except for collateral jurisdiction, and at the time you filed your motions, Mr. Reed, this matter was not on appeal, okay? So we know what jurisdiction is required to issue orders for fees and costs. They're not collateral to the judgment that was entered. The judgment was for monetary judgments arising out of the divorce judgment, and so the court is not going to be able to weigh in and adjudicate these fees claims. The court is also not going to certify to this appellate court to remand this matter because prevailing party is a significant principle in the evaluation of these claims, and so you're stuck. That appellate process hopefully will be resolved efficiently and quickly. There's also been subsequent filings, Mr. Reed. I assume that you're responsible for these filings for Ms. Kellogg seeking additional court relief, course of powers of indirect civil contempt, right?
That is correct.
All right, those are collateral, but the court is not going to litigate this matter while you're on appeal. Okay? I'm not setting contempt hearings. I'm not going to waste the court's time as far as dealing with it in that fashion. You have the power of the, you have an order upon consent that you, I think you were party to this, right? So you have an R case that you can seek collection there, and you're litigating the validity of the judgments that the court entered. So, do you want to be heard on any of this? I mean, I know you know the law. The Honeycutt case applies. The court is not going to be litigating this matter while the appellate court has jurisdiction.
I do, Your Honor, and the point I want to make, obviously, we disagree with the court's analysis regarding this being an ancillary matter that is not subject to the court's ability to address the attorney's fees. But putting that aside, the court does have the ability to enforce its orders.
Sure I do. Yeah, that's right, but it'll be enforced in the form of what? A judgment? I'm not having an indirect civil contempt hearing on this case. I'm not doing it right now, okay? There's so much stuff going on in this case, not only the appellate stuff, but you've alluded to, I read the protective order that you filed, all of the cases that are pending with this matter. I'm not going to. These folks have had unbelievable volumes of court resources as it relates to this financial dispute, okay? It is not your client's right or your right, indirect civil contempt. It is the tool of the court, okay? And I'm not issuing a show cause. I'm not setting aside a half a day for this matter to be heard, to determine whether or not Mr. Ghibaudo is paying any or part of these financial obligations that are on appeal. Now, I don't know how long I'll feel that way, but I'm certainly not going to do it as this, basically this lockstep approach where I'm hearing this case for years, every other month.
does is that it gives Ms. Kellogg no remedy to get any support. And the court addresses...
Of course she does. She has an order upon consent. He's under a contempt, he has to answer to that. We also know, I don't know the details, but there's all this, all this, I guess, specter of licensure issues and other things that are referenced in the protective order case and the DA case and the, this case. So there's a lot of coercive acts that are going on as far as getting paid. And in a sense, the court understands where you're coming from and isn't certainly sanctioning ignoring the orders, okay? What I don't like is this parade of filings during the course of the time since November, expecting the court to basically have a hearing every other month on this case. As time goes by, if there is no, I guess the failure to make payments as ordered, maybe the court will feel differently about it. But you've been on this case long enough now to see what the court has done. I mean, there were times in this case where I was having a hearing every month to make sure that those payments were being made. Okay? I'm not going down that rabbit hole again in this case right now.
And I appreciate that, Your Honor, and I understand the court's ruling as much as I may disagree with it. Obviously, there comes a point in time where failure to comply with a court order, it becomes just
Mr. Reed, the sad reality is the court has two tools as a remedy. A financial sanction of $500 per finding of contempt after going through all of the due process pieces of it, or essentially putting someone in custody as a coercive power to get the payment. Neither which of them are things that are likely to happen in the short term in this case, okay? There are a lot of other remedies of coercive power that are out there that are not necessarily in the court's position that are at play in this case. Not in this case, but in the cases that involve these folks, right? I mean, if Mr. Ghibaudo doesn't pay, or if I guess I took this order upon consent when I saw it, and of course I have to sign these when they're sent. It's sort of a reset for him, right? A hope that he'll comply with these orders. A resolution of this small piece of the case. If he's not complying with them already, then he'll have to answer to them too. But look, I sympathize. It doesn't do me any good for the court to be talking to your client in terms of, I expect the orders to be followed, I want them to be followed, I'll assist in the manner in which the court can do it, because I probably said that to her maybe 15 or 20 times in this case. And had hearings that have been, what would, if the court was entertaining any of this collateral tools, I'd be issuing a show cause, carving a portion of a half a day out so that the matter could be heard for you to prove what he hasn't paid since the last order, a month or two ago? November 10th, 2020, or January 14th, 2021. I'm not taking the valuable court time away from other cases that have been waiting to be heard for that purpose in this case.
To be clear, Your Honor, you had ordered it to commence October 1. So
I know that. I'm just saying these are the dates of the orders. That would be the operative jurisdictional piece of it, right? Clear order, notice of the order, failure to comply, clear convincing proof without defense, right?
We understand the court's ruling.
Yeah, look, you can sense the frustration that I have in dealing with this case. The fundamentals are that the orders are supposed to be followed, but we're not going to. The appellate process needs to be uninterrupted. That based on the findings and orders, the orders that were entered as it relates to fees, if those orders stand, it's mandatory that I consider fees and costs. But your initial motion, I don't really want to comment on it. Basically, you threw everything but the kitchen sink in there, going back to years. You know that you're not entitled to a judgment on these proceedings that are related to fees that you paid prior times when judgments were already entered. That would be a fee request related to the litigation that was specifically resolved in September. Okay? Now, I take that to mean about $13,000 in costs and about $80,000 in fees to you, right?
Your Honor, just to be clear, the issue regarding attorney's fees that were deferred go back to everything after the last time this court entered judgment.
Right, so I suppose you would need specific rulings if the court was gonna go there about what portion of, if any, Mr. Willick's fees would be awarded. What portion, any of your predecessors, I can't remember them off the top of my head.
No, it's okay, Your Honor, yeah, absolutely. Each time those attorney's fees were deferred. And so I understand, once again, I don't want the court to feel that we are recalcitrant at the court's ruling.
No, I don't feel that way, but when you exercise your right, as both of you have, to appeal, a byproduct of that is basically a loss of access to the district court on many of these issues.
Like I said, we understand the court's ruling.
All right, so, and of course, you know, the whether or not we go forward with a request for a show cause or contempt proceeding, that's always without prejudice, okay? All it requires is a notice and a jurisdictional affidavit to ask the court if it would take a different approach. My feeling about all of this is that, my goodness, since this matter was decided, and I do appreciate you getting the findings in writing and filed so quickly, less than 6 weeks. We've had 1, 2, 3, 4, 5, 6 substantive filings in this case, asking for relief, maybe more. There was one filed today, I think, by defendant. So anyway, Ms. Kramer, you're counsel, right?
Yes, I am, Your Honor.
Okay. Look, your client exercised his right to appeal with the first notice filed in the case. The court is not excusing if he's in not in compliance with the support agreements that he made or the orders that have been made. He's at risk. And while the court's not taking up a contempt proceeding this month, that's something that the court can look into if it's necessary. Okay. And if he's not complying with his agreements and orders, it's at his own peril. Finding him is meaningless. I've issued judgments before. Putting him in custody is something I would like to avoid at all costs. But it might come to that. That's why we're not having the hearing right now. Getting every opportunity, anyone who looks at this record will see that he's had more opportunities than most to come correct and meet his financial obligations. So, Mr. Reed is going to be directed to prepare a specific order that says that, based on the appeal, the court determines that adjudicating costs and fees requests are not collateral to the financial judgments. I think they're directly related because the amount of fees and costs are really tied directly to a prevailing party principle. Even if they were collateral, the court is not certifying pursuant to the Honeycutt principles a remand for the purpose of adjudicating that. I want to know who is the prevailing party before those issues are adjudicated. So, Mr. Reed, it's a denial without prejudice, of course. Okay. Ms. Kellogg's recent motion for sanctions and a show cause and a request for an indirect civil contempt hearing is denied without prejudice for the reasons that the court has said. The court has determined that it's not right for the court to engage in an arc of litigation that would be a contempt proceeding to either fine or use the jail as a coercive tool to get compliance with the order at this time. But that doesn't mean, Mr. Reed, that you can't make a request on a jurisdictional affidavit as time goes by, okay? Because that request is clearly collateral to the jurisdiction of the court, to the judgment that's on appeal. And so that is I want you to refer that separately. That's the one that was set for hearing on February 23rd, because that hearing is, that motion is going to be denied without prejudice, and the hearing will be vacated, okay? And Ms. Kramer, Mr. Reed will give you the opportunity to review the form and content, but I want the order submitted, and if you object, give him a written reason. And Mr. Reed, you can determine whether you want to submit it, and I'll review it.
Thank you, Your Honor.
All right.
All right,
Thank you, Your Honor.
all right, look, stay safe, and hopefully this appellate process will be resolved quickly.